This is the calm before the storm right here. That senses down. It's trying to create some drama. No, Ron. Drama alert. Drama alert. Here comes fire. Back on fire.
To be famous boy.
What's up, guys? It is Boot Body Can, Boot Productions. Welcome. Well, guys, we have I don't want to say fun-packed show, but we definitely have a very informative show coming up here. So thank you all for being here. We got 22 people starting off. But yeah, guys, so we had some individuals who have made some pretty big promises. Seems it's taken them quite a while to fulfill said promises. So I figured, you know what? Why don't I go ahead and why don't I just do better? You know? So with that being said, guys, if you guys want to review the transcripts from the last hearing for Amber Brown v. Christopher Ryder, put a 1 in the chat because we might just review those transcripts. I mean, I'm just saying we might possibly have access to those. Might review them. Possibly. Maybe. Perhaps. Maybe. Ooh, got a lot of people here. I want to see them. And you want to know the best part about the whole thing, guys? I didn't have to grift for it. I didn't have to grift. You find people for it. Not 1 penny. Not 1 penny. So, well, guys, I'm not going to share the first page because it does share addresses, and I am not going to share that. That would be a violation of TOS. So, before I share this, let me scroll through because it's pretty long. And we're going to be going over the amount of pages, how much it costs to get the record, because some other people were throwing other numbers around. And I'm just like, whoa. Okay, so we're actually good past the first page. So let's do this. Let's get back up to said second page. All right, guys, here we go. So this would be the transcript for the last hearing for Chris Ryder v. Amber Brown. And here, I'll even zoom in. That way people can see it. If you guys think this is good, you guys can see this, put a 5x5 in the chat, I guess. That way I know it's good to go. So, but yeah, this is the actual record. And somehow after the show, I'm going to figure out a way to post a public link to where basically anybody who clicks said link will automatically download this exact same PDF. That way you guys have a free copy of it. You know, that way you don't have to make unnecessary donations off false promises. So, but yeah, guys, once again, we're reviewing the record from the last hearing for Amber Brown v. Christopher. So here it goes. February 3rd, 2026. Called to order at 10:22 a.m. The court. Now, when they're referring to the court, for anyone who's not aware, they're referring to the judge. Okay. And when you see respondent's going to refer to Christopher Ryder, the one who is responding to the claims. Okay. So when it says claimant or plaintiff would be Amber Brown. Respondent would be Christopher Ryder. Okay. So the court. Okay, Amber Brown v. Christopher. I always can't remember. Is it Ryder or Reader? The respondent, which is Chris. It's Ryder. The court, Ryder. The respondent. Well done, Judge. Wow, Chris. Holy fuck, man. We're just coming out swinging right out the gates, just being a condescending dickhead, huh? I'm sure that's a good way to win the judge over, Chris. Keep in mind, these are just the words recorded, but I can't even imagine the inflection you put in your little voice over that. So here you go. The judge of the court. Okay, come up, please. The clerk. There is a motion to reset. The court. Excuse me. The clerk. There is a motion filed to reset that hearing. The court. Okay, all right. You're Amber? The petitioner, which would be Amber. Yes, Your Honor. The court. And you're Christopher. The respondent or Chris. Yes, sir. Mr. Singleton. Judge Tony Singleton. I have not entered my appearance yet, but I anticipate doing so forthwith. The court. Okay, have a seat. Is Todd Bryant in the courtroom? Mr. Bryant. Yes, sir, I am. Well, there you go. Guys, you know what? Todd's a lot of things, but at least he's respectful to the judge and doesn't just come out right away being a condescending dickhead. So, the court. Come on up and have a seat, Mr. Bryant. Is Tiffany Napier in the courtroom? Miss Napier. Yes, Your Honor. The court. Come on and have a seat if you would, please. Mr. Bryant. Where would I sit? The court. You can sit there. You can have a sit over here. You can sit over here, ma'am, which I'm assuming he's obviously talking to Courtney. Not Courtney. To Tiffany. Okay. Miss Napier, over here. The court. Yeah, all right. We're on the record on 31 DO1 2512 SC 95. Amber Brown v. Christopher Ryder or Reader. he's like taunting Chris, dude. That's hilarious. Okay. The respondent. It's Ryder. You had it right the first time. The court. Ryder. The respondent. Yes, sir. The court. All right. I'm going to put a big I over here to remember this. All right. Everybody's cell phones are off. Does everybody understand there's no video or audio recording of the hearing? Okay, I've got a script here. I've spent a lot of time writing. I want to go through this with all of you and allow your counsel to respond after I have done this. We were scheduled today pursuant to a notice of the claim that was filed December 3rd, 2025 with regard to Amber Brown and Christopher Ryder. I am at this point in time. I just want to give you all some comments. We're not technically having a hearing at this point in time, taking evidence or anything. I need to explain to you all the senior judge process here. For 22 years, I was a judicial officer in Clark County, and I handled cases in Clark County, and I retired 4 years ago, and I became a senior judge. As a senior judge, I'm employed by the state of Indiana, specifically the Supreme Court of the state of Indiana, to handle judicial matters in any trial court in the state of Indiana. Whatever judge needs me can call me, and they may say, I need you for a day. They may say, I need you for a whole week. I'm on vacation. They may say, I'll be here today, but I've got so many cases. I need you to help me out today. That's the way senior judges work most of the time. As of yesterday, I was in Clark Circuit 4 covering for Judge Reger. She had basically almost a whole day of criminal cases. As a senior judge, we walk into court and we have no idea generally on what we're even expected to do until we get there. We haven't seen those cases. We haven't handled those cases. I try, as a matter of course, when I know that I'm going to be in court like a circuit court, I try to go on my computer and I pull up the judge's calendar and go through all the cases so I can know if I have to do any research or anything before I get there the day, and that I can make any senses of the cases and sound relatively intelligent about what I'm doing. Now, and that's the way 99% of the senior judges' cases are handled in Indiana. With regard to this court here, it's different. The Supreme Court has allowed me to handle Judge Claypool's entire small claims docket. He does not handle his small claim docket. Judge Claypool does not review the pleadings on the small claims docket. He does not hold hearings on the small claims docket. It is totally my responsibility. That sounds like a lot of work. He basically works his way down to about 1 day, maybe a day and a half in court per month, and that includes me sitting at home and reviewing motions and stuff that might be filed. The way small claims generally work, even when you have a judge that's not a senior judge, is a small claim is filed. The clerk or the court reporter schedules a trial, and that trial, with regard to evictions, we try to get within a month. And if it's just with regard to damages or something, I try to keep a little closer to a month. But we schedule those out a little bit further since we're not talking about trying to evict somebody or get them out quickly. So generally, a judge, especially me, has no idea that a case is even filed until I show up the day of the trial. My process and procedure is a day or two before the trial. I go through and get on the computer and I look at my document and I go on every case. Here, oh, here's an eviction. It was served on December 4th. Okay, I've got service. What's the issues? Well, this is an eviction. This is a car repair case. This is a medical bill. And I try to make sure that I have cases that I know that I've done for 25 years. And I try to find cases like the one you had all in the previous case, where there was a motion to dismiss upon the lack of jurisdiction. And back in that case, I spent a lot of time reviewing the case law because they'll both have federal cases that talk about it. We have one of the first things we read about in law school is a case about jurisdiction. And so I'll go and I'll try to review those things. In this case, Amber Brown versus Christopher Ryder, there was a pleading filed, a motion for transfer to the plenary docket because you wanted a jury trial. Okay. Somewhere in the middle of the past month or so, my court reporter received that motion and she put it in my queue for me to look at. If you all remember your other case, there were a lot of pleadings filed and a lot of complicated issues and stuff. And I had a lot of stuff in my queue that I had thought, well, I'll try to deal with this. Which what he's probably referring to, guys, is all those bullshit motions that fucking Chris was filing that Tiffany was basically trying to write for him. Like, you know, even though he says he's pro se, right? But whatever. Okay. No, I can't deal with that. I'll deal with the small claims hearing. I saw your motion. I saw your name on it. And I instinctively thought this is on the first case. And I thought to myself, if this is on the first case, why are they sending it to me? That's for Judge Evans to deal with. That was my mistake. That's what led to one of the issues we're here for today. That was my mistake. I will tell you that if I did see it, I would have deferred it today and not ruled on it, because when I see, like I did last time in your all's cases, this sounds super intelligent. When I see a case that I'm pretty darn sure is going to be taken to the plenary docket, I think you can say preliminary maybe, but okay. I want to make sure that the parties understand that this isn't a simple matter of filing a little form and putting a little paragraph in a small claims pleading, and all of a sudden you're in court and having a trial. I want to make sure that when I transfer it, that I explain to the parties, okay, you're going to the plenary docket and you went from a paragraph or two to this book with a lot of things that you have to do. It tells you how to do them, when to do them. I recommend that. Probably recommend it to tell you all to have an attorney or you get an attorney. And I want to make sure that you all understand that when you get into a plenary docket, even though you filed a little paragraph like this for small claims complaint, you might want to file a really good drawn out complaint so the judge knows what the issues are. And I want to tell the defendant, hey, Mr. Defendant, in a small claims court, you don't need to file an answer. But when you get a plenary court, you have to file an answer. The small claims court, we don't do discovery. In plenary court, you all do discovery and you do this and this. So everyone knows what to expect, and I can send them off feeling comfortable that I've done everything I can to let them know what to look for, okay? So it is routine for me when I see a motion to dismiss or other motion, if I know the case is pending, to hold it to the trial date. So probably would have done that, but I didn't do it, and I probably should have scheduled a hearing or put a note in, motion to transfer. Hearing will be scheduled at the same time as the trial. Okay, but that didn't happen. The respondent, which means Chris, was trying to interrupt Judge, the court. So where does this put us today? You filed a motion, and as I was getting ready to review this case yesterday, I get a call from my court reporter and the clerk saying, we've got this motion wanting to get rid of Judge Claypool. And what on earth is that? Will you send it to me? And it ends up, it's not your simple change of judge motion. It's a motion that asks the Supreme Court to take Judge Claypool off the case and to get another judge. And to attorneys call it the lazy judge rule. So in effect, a motion was filed saying Judge Claypool is lazy and he hadn't ruled on time and we want to get rid of him. Okay. So the problem is Judge Claypool isn't the judge that you should be upset with. Judge Claypool didn't do any. So basically, Chris filed a very severe motion insinuating some pretty severe shit about Judge Claypool, and the judge that's reviewing this is like, Judge Claypool's not the person you should be filing this on, Chris. It should be me, I think is what he's going to say. So here we go. Judge Claypool didn't do anything wrong. Judge Claypool never would have seen that pleading, was not responsible for ruling on it. So I'm looking at the case and I see that you filed a motion for change of the venue to the plenary docket because one of the reasons is that you want a jury trial. Chris, the respondent, correct, the court. So I thought, well, the rule says that you have to do that within 10 days of being served. I looked at the docket. You did it within 10 days of being served. You were entitled for me to order that case be transferred to the plenary docket. Okay. The respondent, yes, sir, the court. I looked at the statement of the claim for the first time yesterday because I don't see those until the last minute, and I see that you filed a complaint and you asked for a jury trial in your complaint. Chris, That's totally Chris, dude. Oh, God, guys, hold on. I gotta get my water bottle over here. So far, like, it sounds like Chris has tried to interrupt the judge, what, 4 or 5 times now, maybe? And I'm sure that's just including the words they've recorded, not the sounds he probably made. So, all right. So let's see here. The court. So you asked for a jury trial and you asked me for a jury trial. The trial rules or the small claim rules say that if you ask for a jury or if you file a small claim, you're waiving your right to a jury trial, but I'm ending up with you're entitled to a transfer. You wanted a jury trial, and I am more than willing, now that I know what's going on, to transfer this case to the circuit court, okay? But since this motion to the Supreme Court has been filed, I talked to the ethics people yesterday in Indianapolis saying, do I have the authority to act at all since the motion has been filed? And they suggested that today I do what I'm doing right now. Make sure I've got both parties. Make sure I tell you that legally, I believe you both of you are entitled to be transferred and ask you are willing to let me issue an order transferring it to show on the record that you're withdrawing your motion to the Supreme Court. Mr. Singleton, and your honor, and then the court keeps talking. Now, having said that, I'll let you talk. Mr. Singleton. Okay, thank you, Judge, and thanks for the court's explanation. Your honor, I might have been able to preempt a little bit of that by just asking that this motion be stricken. The court. Okay, I'll be glad to show you that on behalf of your client have done that. Now let me talk a little bit more. As of yesterday, I see when I'm doing all of this research, I see in the small claims case, you have filed a motion to correct errors and a motion for the judge to be removed. And I think, my goodness, what is this? I thought I got rid of that case. And what happened was you correctly put Harrison Circuit Court in the style of the case, but mistakenly put the Superior Court cause number, so that originally came to us. So I start panicking because I'm looking. Judge Evans is supposed to have gotten that, and he's only gotten a couple more days before he gets a lazy judge pleading filed against him. I did notice this morning that you followed up with that one. You did, in fact, file in circuit court on the 23rd of January, I believe. Chris, the respondent, was that the one against Todd Bryant? The court. That's the one with Judge Evans. That's that. You were asking whether Judge Evans actually dismissed the case, and you filed a motion to correct error and asked that Judge Evans be removed, question mark. The respondent, or Chris Ryder, yes, sir. The court. That has been, we made sure that this court has that. The respondent, thank you. Mr. Singleton. So, Judge, it was just a follow-up to that. Was that so inadvertently got filed this case as well as that case? The court. Because the cause number, it showed up on the Superior Court docket until January 23rd, when somebody filed it and actually filed a copy in Judge Evans' court when he's the one who was supposed to rule on that. Now, I always say small claims is easy to get into, but it's not simple. You have filed a motion to correct error, and most of the time, we want the judge that sat in the hearing and heard the evidence and decided all of this stuff to be the judge that decides on whether or not he made a mistake or not. But you asked Judge Evans to be disqualified, so now we're going to have this issue with some other judge trying to decide whether this judge made a mistake without having been there. The respondent understood. The court. I'll let you deal with that issue. Mr. Singleton. Thank you, Judge. So it seems like the judge is pretty pissed off that Chris filed this motion at all. And he's trying to say that it takes the judge to see if he made a mistake versus a different party, which to me, I'm not gonna lie, that sounds a little odd. Like usually when someone's under an investigation or they're being checked to have made a mistake, it's usually not by the person who like made the mistake, right? It's like the joke about the cops, like, well, we investigated ourselves and we found no wrongdoing whatsoever. So, and sorry guys, there's a lot of people. I just realized like we went from 22 people to like in 10 minutes we shot up to like 70 people. Like holy shit, like that's fucking nutballs. So all the people that hopped in, I'm so sorry. I don't have the time to highlight your comments, but KFAR said, so does Chris just ask for a new judge every time he doesn't get what he wants? Yeah, I'm pretty sure that's what Chris does. I actually think that's a pretty common strategy for a lot of people who don't get the ruling they want. So, all right. So here we go. The court. I'll let you deal with that issue, Mr. Singleton. Thank you, Judge. The court. If you want to change that at all, the respondent. Thank you, the court. And finally, that leads me to the to this you, I guess, as his counsel in this case. I think we are all agreeing that I can transfer. You're not going to want Judge Evans on the case once it gets there, right, Mr. Singleton? Not after that. The court. So he needs to take care of that issue. Mr. Singleton, thank you. The court. Okay, Mr. Singleton. Yes, sir. The court. So given what I have heard, I'm going to transfer this case to Harrison Circuit Court, and you all might want to deal with getting a new judge if that's what you want. You're entitled to one without saying anything bad about anybody to get a new judge. And again, it's a little bit more complicated than circuit court on the plenary docket, but the case will be there. I don't think anybody has been prejudiced because this happened the way it's happened. You can continue with your case. Do you have anything you want to ask me given all those comments? The petitioner, no. Well, I have to likely formally put in a motion if I do decide to seek legal counsel before that next court date or anything, or just show up with an attorney. The court, you don't have to ask permission to get an attorney. The petitioner, which is Ryder, Mr. I act like I always know what the fuck is going on here. So because I know what's going on here, I don't know the difference between bond and probation. I act like I do. I probably learned after I got grilled so hard about it, but I try to act like I know a bunch about fucking court proceedings and legal proceedings and all this, but I don't know that I've got the right to just show up with an attorney one day. Like, okay, right. The court, hire an attorney anytime you want to. It's just that you need an attorney on all y'all's kinds of case. But asking for injunctions that you're asking for this and that, and if you really are going to have a jury trial, the judge is probably going to order mediation and discovery and lots of other things. You're probably not sophisticated enough to do it. Okay. Ooh, dude. The judge is like straight look at Ryder. He's like, yeah, dude, I can tell like this dude's a fucking hard dude. This dude's, oh yeah, petitioner is Amber. Well, I mean, I guess the judge is honestly, he's shitting on both Amber and Chris. He's both basically insinuating they're both retarded, that God forbid they couldn't figure out the discovery process, even though it's not really true, but whatever. It probably is best for them to both get attorneys, especially Chris, honestly, because all right. So let's see here. This is going to be so I would suggest if it was kind of weird. In Clark County, I was a small claims judge, but I also dealt with plenary matters. So I would move it from small claims to a plenary matter. And when I would be the judge of the plenary matter, and in the plenary matter, I would transfer it, and I would automatically myself tell you that I wanted to have a conference with you so I could give you all these other comments. But if you've got counsel, I hope you get one. So I'll just kind of stop where I'm at. Okay, that doesn't make sense to me, but do you have anything else you want to add? Okay, so now the record will introduce a no, I don't believe Amber has an attorney, nor does Chris at this time. I believe they are both working just pro se. So I could be wrong about that at this point. Shit could have changed since this record was obtained, but I don't believe either of them have an attorney. I think they're both pro se right now. So, all right. Now it's going to say unidentified speaker. Honestly, I don't know at this point if the unidentified speaker is solely GS or if it's a little bit of GS and OMC, but I believe it's strictly just GS. Okay. So here we go. Do you have anything you want to add? And I guess he's looking at GS. Unidentified speaker. Yes, Your Honor. The court. I know we're not holding a hearing on your case. Unidentified speaker. Yeah. I'm a little confused as to how I'm called up on this, but I understand. The court. I called you up because I wanted you to at least hear the comments because of this. Unidentified speaker. Understood, understood. The court, their motion to correct error and their motion to get a new judge. I don't know if you knew that was happening or not, but a motion to correct error. You filed your lazy judge thing because you have a 30-day deadline. So at this point, the judge is looking over at Chris. A motion to correct error has a 45-day deadline for the judge to either set a hearing or rule on a motion. And if I understand correctly, correct me if I'm wrong, in a motion to correct error, if the judge doesn't rule after 30 days or after 45 days, that constitutes a denial of the motion and not likely. And sorry, it's not like you do the lazy judge thing there. Unidentified speaker. That's my recollection, Judge. The court. It's a denial of the motion. So you want to make sure that you file whatever you need to file before the 45 days is over. So he will have to review if he's going to rule whoever that person is. Unidentified speaker, which once again I believe is GS. Right, Your Honor. My understanding of Indiana law is an appeal, which is a motion to reconsider. It sounds like an appeal to me. On 12/18 was an automated EN phonetic and notice issued order granting motion to dismiss. It wasn't until 1/23/26 that a motion by the plaintiff was put in for a motion to reconsider and change venue with attached filing. The court, okay. Unidentified speaker. To me, that's added process, Your Honor. The court, that's to be with by the other judge, whatever the fuck that means. Unidentified speaker. But how am I? This has been dismissed. This is past the 30 days of a motion to appeal. This seems like it's a little, and GS gets cut off by the judge. Okay, that's the issue in the case that we transferred earlier. So I don't have any dealings with that. And then he gets interrupted by GS, but you're granting a rejection of a motion to dismiss today. The court, I'm not doing anything with regard to your motion to dismiss at all. And I wonder if maybe that's Tiffany who's talking, possibly. I'm not really sure, but all right. Unidentified speaker. Okay. So how does this, Your Honor, pardon my interruption, how does this involve me? The court. I brought both of y'all up because you were here in the last hearing. Unidentified speaker. Yes, sir. The court. And I noticed this motion was filed and that ended up in this court. And I didn't look like it made it to that. And it didn't look like it made it to that court. And I just wanted both of you all to hear my comments on the fact that I believe Judge Evans now has the pleadings that only came here because they were submitted to them on January 23rd over there. And unidentified speaker, which is over the 30 days limited appeal, Your Honor. The court. So the motion to correct error is the date the motion to correct error is filed is the important date. So my understanding is that was January the 4th. So that's probably the date that Judge Evans is going to be working off of. There's two things you can do as a person. You can ask the judge to change the order because you think you can convince the judge he made a mistake. That's what a motion to correct error is. That has to be filed within 30 days of the ruling, okay? Then, if the judge doesn't change his order, you have so many days to file with the Court of Appeals, or if you want to, you don't even have to file a motion to correct error. You can go straight to the Court of Appeals. That's why I'm trying to tell you that you all need attorneys. You need attorneys to understand all of this, but I'm not doing anything. I think that you were dismissed out. You're dismissed out as of right now. They filed a motion saying, Judge, I think you were wrong in dismissing him. And now that Judge Evans has the pleadings, he will either have a hearing or he'll do nothing. And by doing nothing, that means you won that stage without doing anything, okay? And then they have a right to appeal to the Court of Appeals if they want to, but that's all in the other court. Unidentified speaker. Pardon my layman lack of understanding, Your Honor. The court, go ahead. Unidentified speaker. And I appreciate the leeway you've given me. So appealing the final decision to dismiss by Judge Evans happened almost the exact day that I went to circuit court. So that started the clock for them to put in paperwork to try to ask for your reconsideration. The court, yeah. Unidentified speaker. Now the motion to appeal. When does that timer start? The court. Well, if the motion to correct error is denied, unidentified speaker, right? The court. Then there is a time period. It starts running from then. Unidentified speaker. So that has not been adjudicated yet. The court. Correct. Unidentified speaker. Okay, yes, sir. Okay, that gives me understanding. I appreciate that, sir. The court. So did you get his pleadings? Unidentified speaker. The court. Motion to correct error. Unidentified speaker. I've got the printouts here. The court. Okay. Unidentified speaker. I actually came in here to get a public record request of all the transcripts of my court case. The court. All right. Well, unidentified speaker, because I had a hard time hearing, sir, and I couldn't hear a lot of the stuff that was said. The court. Well, if you don't have the motion to correct error, then the circuit court can print those out for you. Unidentified speaker. I think I have it. The court. And again, the judge has 45 days to either set a hearing or to schedule a hearing. So you want to make sure that he's got your pleadings when he's considering what to do, okay? Unidentified speaker. So, Your Honor, I understand you can't give me legal advice. I'm not asking for it. I am expecting to plead. I mean, my initial motion to dismiss based on lack of personal jurisdiction seems to still stand because I have no dealings here. The court. As of right now, I agree with you. Unidentified speaker. Okay. The court. Okay. Unidentified speaker. So what would I need to plead? I would try to encourage the court. I would suggest you talk unidentified speaker. Again, this would probably be inappropriate for me to ask you. The court, to an attorney. I think you need to talk to an attorney. Unidentified speaker. Thank you, sir. I'll be quiet now. The court. Okay. All right. Okay. I will show for the record that you're withdrawing the request for the Supreme Court to act on this thing and on this case. Amber Brown versus Christopher Ryder will now be transferred to circuit court. There's a small transfer fee that you'll have to pay within 10 days, I believe, and then you'll have your attorneys do whatever they think they need to do, or maybe Judge Evans will schedule something, okay? The respondent, yes, sir. The court, okay. Anything else? Any questions? Do you have anything you want me to ask? The petitioner, no, Your Honor. The court, all right, thank you. Mr. Singleton, thank you, Judge. The petitioner, thank you. Proceedings adjourned, 10:48. Approved by Crystal Thomas. So yeah, guys. So there you guys go. I'm going to figure out how to post a link, and once I get it, I will make sure to post it in my community tab on where you can get a free download of this record. I might take out the very first page because it does have addresses in there, and I don't know if that's something I really want to necessarily spread on anyone's behalf. So, but yeah. Past that, another thing I want to bring up is that somebody was grifting really hard, claiming that stuff was going to be like a certain amount per page, that it was going to be like 150 some dollars and like $128 or some shit like that. And it's just like the whole thing is like in the end, like it wasn't that much. It was around about that much, but in case any of you are wondering, for full transparency, it was about $117 to get this transcript. So it wasn't 150, it wasn't 128. There was no padding of the amounts there. So, which came out to $550 a page at 18 pages. So, yep. Pun KTZ to Sweepy Pie over here. So, Toyota Tom said, why didn't anything happen with Brown v. Ryder? Basically, from what I can see, it looks like they're pretty busy. And honestly, I don't think these judges were taking this specific case very seriously. It seems like there was a lot of kind of backtracking. They made a lot of decisions in the background while the parties weren't aware of what their plans were to do. And I think it kind of caught them all off. But it sounds like basically from what's being said that there'll be another hearing for a review on whether they think Ryder was right or whether they think he was wrong. And the judge was in the end completely right on his assumption, which, here's the thing. I think both these guys are fucking doofuses. I think that they both share a lot of different qualities. Lying, manipulating, taking shit out of context. But here's the thing. In the end, I don't see Ryder making it out of this on top. I think that I think Todd's got him on that, honestly. It's just the way I see it. So you guys can have your own opinion. That's my personally. So, but yeah, I was going to get the Blues Clues. We just got a letter music and download it so I could be like, we just got a record. We just got a record. Wonder where it's from. But I don't have that. So But yeah, guys, I mean, that's it. We're like at 40 minutes basically. 90 people in here. I would love to continue on. I don't really have anything else to say. Um, well, I guess no. I could share it, but um yeah. All I can say is I guess if you guys want to tell a certain individual, I know they grifted a lot of money for this transcript, but if they want to, you know, give some of that money back, they don't have to pay me directly. They can actually just give that to Mr. Carey where it belongs. So, but yeah, you're welcome, KTZ. We just got a letter. We just got a record. Wonder where it's from. All right, you filthy animals. Well, get the F out of here. Boot don't love you no more. Boot wants you out of here. Get the F out of here. We're not monkeying around anymore.
This monkey is healthy and normal in every way, but now watch. My God, he's become full of rage!
Who would have known, man? You piss in the monkey's face, it gets pissed off. But yeah. All right, well, love all y'all. Appreciate all y'all. Really wish I had something to review, but unfortunately, I don't, because I suck. I'm body cam and I'm horrible.
You're still here? It's over. Go home. Go.